Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Hello, my friends. Happy Monday. Fun day, Monday. Here we are. With some more news on Karen Read. How about that? We thought it only happened on Fridays, but it actually happens on Mondays now, too. It's going to happen every day until this retrial is done. And now, based on the current filings today, it looks like the judge has an opportunity, if she so chooses to take it, to put the trial over from January 27th of 2025. How is everyone today? Thank you so much for coming to hang out with me. It's Monday, November 4th of 2024, and this is hot off the press again. Just filed about an hour or two ago. We're here to break it all down for you. I'm here to break it all down for you anyway. Thank you, Lori Life 360 for the win for gifting 5 memberships right off the bat. And welcome to the 5 new members who were randomly selected by YouTube. You are not only a winner today, but every day. Thanks to Justin also for the Cash App. Let's give everyone a little chance to get in here before we get into the papers, because that's what we do. We like to get into the papers. I saw, Sean McDonough broke. Somebody sent me on Twitter a bit ago that Michael Proctor was fired. But since then, Christina Rex has come out and tweeted that no, in fact, social media reports of Trooper Proctor being terminated are not true. He's still under internal affairs investigation and is suspended without pay. So I don't know. I don't know what's real, what's not real. Here in the Upside Down, we don't ever really know what's true, what's not true, what's hyperbole, what's fluff, what's real, what's fake. We don't know. The PR crisis over at Norfolk County District Attorney's Office and the MSP is real. It's real. So never a dull Monday. It's just another manic Monday, you guys. Just another manic Monday. So who knows what's real? Will Bev allow it? That's the question. Will Bev allow it? I don't know. I don't know why people believe lamestream media. I'm just giving you both sides. I'm giving you both sides. Sean McDonough says Troopers terminated. Christina Rex claps back and says, no, not true. I don't know which is true and what's not, because we're in the Upside Down, as always. And so we remain until such time as the Karen Read trial is retried. Karen Read case is retried. Hello, Goodmans. Thanks for gifting a membership. They're awesome, the Goodmans. They share an account, husband and wife. And they spend their kidless nights when their kids are out watching here with us. So thank you, Goodmans, for gifting. Welcome to you guys, as always. All right, let's do this. Let's break it down. Let us break it down. The Commonwealth, document number 402. There's 402 filings in the Karen Read case. God save the Commonwealth. The Commonwealth. of Massachusetts. So this motion was actually filed. They say it's filed jointly, but it's actually filed by the Commonwealth. And what had happened was they got the defense attorneys to agree to it. So here's what it is. And it was filed today at, look at that, 3:00 something p.m. And look at us here at 5:30 getting it done. And I think I actually put the stream up around 3:30. So I'm on it for you. And I wanted to give you all time to get notifications. So hopefully you got them. Loves Andrew Myers says, God gave up on the Commonwealth a long time ago, in my observation. Thank you, sir. Thank you, sir, for tuning in. I've seen your show. Somebody pointed it out to me the other day. So welcome to a Massachusetts attorney, right? I think, aren't you, Andrew, from Massachusetts? This is the Shonda and Michigas. All of the things. Yeah, BL, I don't waste any time. You kidding me? I'm sitting here waiting for this stuff to happen. I'm waiting for it. I'm waiting for things to drop. All I got to do is hair and makeup, and I'm here. Hi, Kelly Reed. Hello, Kelly Reed. Heard you guys had a standout yesterday in Fall River. I heard there was a great turnout, and I think that's awesome. Kate C says, Uncle Hank already wheeling and dealing. Either that or he's chewing up his retainer so he can put in for an extension of his 9-month contract and increase the cap on the $75K that they're going to pay him at the whopping rate of $250 an hour, which is practically what plumbers are making here in New York. So, you know what? Good on Hank Brennan for taking the old discounted rate and giving the Commonwealth a break, because apparently nobody else in the district attorney's office wanted to touch this case. That came out in the Vanity Fair article. So, there's that. Hank Brennan is the lucky guy who caught the hot potato. Let's put it that way. All right. This is the Commonwealth and defense joint motion to continue the trial date. And reads as follows. This case is scheduled for trial on January 27th of 2025. The Commonwealth and defense are jointly requesting a continuance of the trial date until April 1st of 2025. I mean, how fitting is it that it's April Fool's Day? Is this a joke? Are we being punked? The joint request will allow both the Commonwealth and defense adequate time to prepare for the trial, accommodate the schedule of new witnesses, including expert witnesses, will allow for the testing and disclosures by the experts timely before trial, and will result in a far more efficient and streamlined presentation of evidence by both parties. Well, one can only hope. What, if any, may just not be in the vocabulary of Mr. Brennan? And wouldn't that be so much more fun and streamlined? It would cut at least, I don't know, a couple days off the trial at least. And all of a sudden, there is a special district attorney anyway who's concerned with the timely exchange and disclosure of experts and testing. The Commonwealth has recently filed a notice of its intention to retest forensic evidence. We went over that together. Further, the Commonwealth has provided notice to the defense that it has retained a biomechanical engineer who is expected to testify at trial. We talked about that as well. The Commonwealth's biomechanical engineer cannot provide a report to the defense until the forensic testing has been completed, a time frame that is as yet unclear, like so many other things in this case. Although maybe, did we talk about the biomechanical engineer? Now I can't recall. We've talked about some discovery that they turned over, but I'm sure maybe they'll say who it is. A real battle of the experts. I don't know about that, because you'll see that it looks like Trooper Paul is still on the payroll. Yeah, exactly. Biomechanical engineer who's willing to drag their reputation for the mud through this. We'll see. Moreover, the Commonwealth has provided notice of additional experts who did not testify at the first trial, and further intends to retain additional experts beyond those, to infinity and beyond. We're getting it done at $250 an hour. These new Commonwealth experts are also expected to generate reports following testing and analysis, which the defense will need time to consider and potentially respond to possibly with additional experts of its own. The Commonwealth will be filing Rule 17 requests and motions in lemonade, and at least one Lanigan hearing for one of the defense potential witnesses. Well, I wonder who that's going to be. A Lanigan hearing is what we call in New York a Daubert hearing. I say Daubert, some people say Daubert, but it has to do with the admissibility and voir dire of an expert and whether or not they should be allowed to testify as an expert. The Commonwealth also expects to file a motion for reciprocal discovery and defense expert disclosures. It is expected that this evidence will be relevant and material to the Commonwealth, and of course will need to be provided to the defense in order for the defendants to adequately be prepared for this trial. The Commonwealth is doing everything in its power to be as expeditious as possible to properly prepare for this trial and ensure the defendant is given a fair trial. The parties jointly believe that the additional time is necessary in order for both sides to be prepared for trial and litigate any additional matters prior to the trial, and therefore provide for a more efficient, streamlined, and shorter presentation to the jury. Well, anything shorter than 9 weeks would be a win. XOXO for the Commonwealth, Hank Brennan, Special Assistant Attorney. For the defending, Karen Reed. XOXO, smooth as butter, Alan Jackson, and our friend David Yannetti, brother of Queen Tanis, dated November 4th of 2024. That is document number 402. Oh, look at that weird thing that just happened. I don't know what that is. Now we go to document 403. And this is the affidavit in support. Affidavit of counsel supporting joint motion to continue the trial date. I, Hank Brennan, appointed as the special prosecutor for the Norfolk County District Attorney's Office, do hereby state that the following is true to the best of my information and belief. Well, at least he stopped saying, my name is Hank Brennan. like he had a big red, my name is tag stuck on his shirt from some sales conference. On September 17th of 2024, I was sworn in as a special prosecutor to represent the Commonwealth in the trial of Commonwealth v. Karen Reed. On October 11th, 2024, I filed a notice of appearance with the court. On October 11th of 2024, I filed the Commonwealth's notice of discovery 47 with the court and provided the notice and discovery to the defense. Discovery notice 47 included but was not limited to a copy of updated Celebrite report of web history, number 15, a copy of the curriculum vitae of Judson B. Welcher, PhD, and the CV of Hannah Knowles. On October 11th of 2024, I filed a notice of scheduling of reassembly and testing of defendant's Lexus telematics systems. Motion number 393 requested a 14-day hearing date. The defense requested the date of November 13th, and the Commonwealth agreed. Because the telematics system is going to be miraculously restored, repaired. The chip-offs are going to all of a sudden reassemble. And evidence is just going to now reveal itself because that's the way it goes in Norfolk County. Who knows? On October 18th of 2024, I filed the Commonwealth's notice of motion for records, Verizon records. I believe these are Bill Reed's Verizon records. Reaching. And Commonwealth's motion for records from Boston 25. They wanted as you recall, the outtakes from the interview on Boston 25 of Bill and Janet and Nathan Reed. And you may recall that they misquoted Ted Daniel in that motion. So in my opinion, that motion was disingenuous. Or just a scrivener's error. 7, undersigned counsel is in the process of reviewing and indexing discovery. Well, I don't know. Oh, so he's got to review the whole file. Right. Right. Undersigned counsel has retained several new experts for trial and expects to hire additional experts. Undersigned counsel intends to file several Rule 17 motions for records. Undersigned counsel intends to file several motions in lemonade. Undersigned counsel intends to file a motion for a Lanigan hearing relative to one of the defense's potential experts. Undersigned counsel intends to file discovery motions and/or Rule 17 motions for discovery relative to two accident reconstruction experts called by the defense at the first trial. Oh, you mean the crash daddies? I have spoken with the defense. It's agreed that a continuance is necessary for both parties to adequately prepare for trial. A continuance will allow the Commonwealth to retain, consult, and disclose all expert materials to the defense and further allow the defense to consider additional expert witnesses of its own and provide timely reciprocal discovery. Signed under the pains and penalties of perjury, this 4th day of November 2024, Hank Brennan. Well, it looks like they're going to be trying a whole new case. They're going to be trying a whole new case with a whole bunch of different experts and a whole bunch of different things and stuff and hocus pocus and shenanigans, and I'm here for it. Here is their latest discovery exchange, because it wouldn't be Monday without document number 404, which is the Commonwealth's Notice of Discovery 48. Now comes the Commonwealth in the above captioned manner and indicates that as of this date, the following discovery and materials have been provided to the defendant through defense counsel. Number 1, copy of no bills from grand jury of March of 2024, and that is 24 pages long. That was the grand jury that the Norfolk County District Attorney's Office tried to weaponize to indict Karen Reed and Aiden Carney on conspiracy charges to intimidate witnesses. All the way back in March of 2024, which was before the first trial even started. There may be some interesting tidbits about that, because didn't Lally, never mind. Lally did a lot of things. He may have represented to the court that this was ongoing or something such as like that. Do you remember? Number 2, copy of transcript of Karen Reed's interview with Boston Magazine's Gretchen Voss on June 20th of 2023, 202 pages. Well, it's interesting to me that that was never turned over the first trial, because, and neither was the grand jury, no bills, because they had all of this stuff before the first trial. So the fact that they're just now turning it over is a little, sus. Number 3, copy of transcript of Karen Reed's interview with Boston Magazine's Gretchen Voss on July 13th of 2023. So the first one in June of 2023 was 202 pages, and then the second one is 17 pages. And didn't Gretchen Voss buddy up with some of the people on the dark side after her interview with Karen Reed? Number 4, copy of transcript of Karen Reed's interview with 2020, 90 pages on September 6th of 2024. Well, there's one thing that happened after the trial was over. Listen to this, my friends, because this gets better right about here at number 5. Copy of Massachusetts State Police Trooper Joseph Paul's supplemental collision analysis and reconstruction report dated July 24th of 2024, 16 pages long. A bait stamp is just like it's a stamping system for the court where documents are numbered. But it's called a Bates stamp. This is very odd, the way they call it bait. It's a Bates stamp. but nobody asked me. And it's the first time in the history of this case that they've started using that terminology. Sort of like during one of the pretrial hearings, they started calling each other my brother, my sister in court to the opposing counsel when they were referring to them in court. And then it just sort of went away. And I've been told that that was a Massachusetts thing. This is the Commonwealth that is exchanging these things. They're not asking for them. They're turning them over to the defense right now. So somebody thought it would be wise to have Trooper Paul go back and do some more collision analysis and reconstruction to the tune of another 16 pages. Back in July of 2024. The mistrial was called on what, July 1st of 2024? So 3 weeks later, before Hank Brennan even came on scene, they had him go back and do a supplemental report because I guess they thought they were going to hang their hat on him. Number 6 is copies of photos from Trooper Joseph Paul's supplemental collision analysis and reconstruction report, dated July 24th of 2024. 140 photos Trooper Paul took. So, I mean, the fix was in right away. Right away. They're planning on retrying this case right away. If he's already doing this 3 weeks after the mistrial was called or declared or proclaimed or proctored, they're already gung-ho. Guns a-blazing. Here we go. We're doing this again. Get back in there, Trooper Paul. Give it another old college try. Let's see what you can come up with this time. Something better than a pirouette, maybe. Something better than it just did. Something better than, the crime scene spoke to me. Did the crime scene tell you anything else? That was one of my favorite moments of the trial. Did the crime scene tell you anything else? Number 7, copy of video from Massachusetts State Police Trooper Joseph Paul's supplemental collision analysis and reconstruction report dated July 24th of 2024. Oh man, I want to get my hands on that video. First of all, they spelled Joseph wrong. Jospeh, but we've learned that they are not the best at spelling, and nobody really proofreads over there. So, no big whoop. But can you imagine the video of Trooper Paul going through his supplemental collision analysis and reconstruction? Maybe he took some more classes, so he's more qualified. Maybe they sent him back to school or Zoom school between July 1st and July 24th when he tried to give this another college try. Oh my, I hope he testifies again. And I even hope that if the Commonwealth dumps him, that the defense calls him, because it was just so fun. The day that Mark Bederow and I were in court was the day that Trooper Paul took the stand on direct, the first day of his testimony. We were there for that. But the cross was so much more fun. And it was better to watch it on TV because then I could talk to you about it while it was actually happening. Number 8, copy of Massachusetts State Police internal investigation report on Lieutenant Fanning. Received redacted from the Massachusetts State Police dated July 15th of 2024. And that is a 6-page long IA report on Lieutenant Fanning. What did they say? What did they say? They said he was cleared. Lieutenant Fanning was cleared. Meanwhile, aren't his fingerprints all over the Sandra Birchmore investigation or lack thereof? Wasn't he the one who reviewed Nick Garino's extraction of Matthew Farwell's phone and found zero text messages between Sandra Birchmore and Matthew Farwell? But I think they said he was cleared, right? Hello, Mazza. Hello. Hello. Yes, they cleared Fanning, but he was also in charge of the jury. Interesting. And here's a number 9, an email from Daniel Linden, dated October 25th of 2024. I don't know who that is. Does anybody know who Daniel Linden is? I mean, there's a couple of them on LinkedIn. One of them works for Walt Disney, so I don't think that's him. But does anybody know who Daniel Linden is? My armchair detectives. Then there's a copy of the supplemental report of Shannon Burgess. Stephanie, I can't even watch you do secondhand embarrassment. I don't know what you're talking about, but I'm sure it's very funny, and I'm sure that was a very funny comment. Shannon Burgess, as you may recall, is one of their new experts who is like friends with Jessica Hyde, who on his LinkedIn page it says, "Hey y'all, I'm Shannon. Do you want to solve mysteries and make sense of complex cyber challenges? You're in the right place." Calls himself a digital forensics expert, hardware hacker, and mystery solver. We went over his credentials a while ago, but he's going to be their new, I guess, expert with regard to forensics, digital forensics. He calls himself a dedicated digital forensics guru. Oh no, he says, "I'm not your typical digital forensics guru. I use hardware hacking and reverse engineering to find data in complex systems like vehicle systems and damaged devices." Oh, that's the guy. That's the guy who's going to magically make the telematics stuff appear. He's reverse engineering. That's exactly what they need, is a guy like him. Exactly what they need, because they need someone who's able to reverse engineer their theories into something digestible, perhaps believable, and perhaps reliable. Creepy goofy. Oh, you guys are great. You guys are so great. Auntie Bev's ready for him. Thanks for being here for 6 months. Happily spinning with class in the Twilight Zone. Thank you. Thanks for coming in and hanging out with us tonight. Romy, did Judge Cannone deny a joint motion to continue before the last trial? She may have. She may have, but here's the difference. This time, it's the Commonwealth who's really asking for the adjournment. This time it's the Commonwealth. And as you know, because we're going to watch it together, the appeal is going to be argued on Wednesday, and we're going to be here and we're going to watch that together live. Those of you who would like to join me, that is going to be at 10 a.m. No, actually, hold on. I don't want to lie to you. Actually, that's going to be at, I don't know what time yet. Maybe 2 p.m. I'll have to check the calendar. But this time it's the Commonwealth, who's asking for it. So, who knows? They may agree. Thank you, Kimberly. Thank you, Kimberly Lapine, for gifting 5 memberships. I appreciate you so much. Boston Sarah, are we thinking they're bringing back Trooper Paul? I don't think I can handle that again. Either they are bringing him back, or they're turning over stuff under their Brady obligation, that even if they're not going to use him, they have to turn over any supplemental reports that he rendered. So, I mean, it's comic relief though, isn't it? Lori says, the more I hear this, I think that the trial's not going to happen. And to your dad says they continue 9 a.m. 9 a.m. The appeal will be heard on Wednesday, and we'll be here covering it together. Thank you very much. They continue to try to run out the clock so that they can impoverish Karen Read. Well, she's already $5 million in debt to her criminal attorney. So yeah, let's just keep this going as long as we can. A 6-month stay was granted already on the civil case, only with regard to discovery from Karen Read. So in the meantime, they can get moving on the civil discovery. They can get depositions of the plaintiffs. Paul O'Keefe, Mr. O'Keefe, Mrs. O'Keefe, and the niece, because the plaintiffs are deposed first in civil cases. Joe Flip ahead in the house. This all feels so dirty. I know, it's all dirty, isn't it? This is so dirty. Story that got her indicted, along with investigators that testified, are all being changed. How can that be allowed? Clean slate, right? New trial, new special district attorney, because nobody else in the office wanted to touch the hot potato. I never understood from jump how they could try her, how they could attempt to try her on both murder and manslaughter. It's like, you kind of got to pick one. Either she intentionally did it and you go with that, or she didn't and you go with that. It's not like, okay, she intentionally did this 24 miles an hour, 60 feet in reverse, gunning it, hating him, jealous about Marietta Sullivan, making out with him in the lobby in Aruba. Or, she just like did it by accident. Like, you have to pick one. It was just the whole thing was really weird the first time. And we're in the twilight zone. Just accept it, go with it, come with me in a world of pure imagination. Maybe that's what it is. It's more like the chocolate factory in Willy Wonka. Cool Blue, what the heck can they possibly do with the Proctor situation? How long are they going to keep Proctor on? I don't know. Can they really keep him on until the next trial? If now this gets pushed over to April Fool's Day? Be interesting. It'll be interesting to see what the judge does. Because if this appeal is going to be argued on Wednesday, which is the 6th of November, the panel of judges will then have to render a decision. It's not going to be from the bench. It's going to be a well-reasoned written decision, unlike many that we've seen or not seen in the other case, like Delphi that we're talking about right now. There are never any written decisions. It's just sort of like, I said so. And then there are some options there. The appellate court can send it back to the trial court for a hearing and to bring the jurors in. I suppose they could just dismiss the charges if they wanted to. That's not really likely. And then they'll have to have time for that hearing, and then there'll have to be a decision on that, and then somebody might appeal it, and who knows? So I'm sure that's why the defense said, okay, we'll just agree. If you want to, have a couple of extra months, we'll agree to that. No big, it's probably going to get pushed anyway with whatever happens with the appeal. Miss Avengers book mouse like, fine, I'll watch Willy Wonka again. Thanks for your super sticker. Hi, J. Michael RN. Thanks for hanging with me for 4 months. Nice to see you too. Thanks for helping us or keeping us up to date on this case. Such a travesty. I feel they're just trying to harass her to hide their incompetence. I think you're not alone in your feelings. Your feelings are valid. I would say this is like the worst we've ever seen, but after covering Delphi for a while, it gets worse. But again, John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. It just didn't. But here we are again. LR Center, thanks for the 20. Is Hank being blackmailed or is he stupid? Are those the only two choices? Should we do a poll? Or does he want to run for district attorney? I don't know. I don't know what his aspirations are. I don't know what's in his head. Don't they recognize that this trial is exposing their illegal activity and the feds are watching? I don't just mean this rhetorically. I would really love your thoughts and conjecture. I mean, I have no information about whether he's being blackmailed. I can't speak to his mental capacity, but I don't think he's stupid. I think he's probably a very intelligent trial lawyer, highly respected criminal defense attorney. Nobody else in the district attorney's office would touch it. It was a hot potato. I don't know if he has political aspirations. I don't know if I don't know. I mean, your guess is really as good as mine. I'll take guesses in the chat because at this point, I don't know what to think, like at all. Hank lost a bet. Yeah, that could be it. Owe somebody a favor, lost a bet, notoriety, but not really. Like, does he need it? I don't know, but you know who might know? My special guest who is joining us today, and I wasn't sure if he could make it, so I didn't want to tell you until I knew that he was coming. But say hello to your friend and mine, the one, the only Mr. Mark. Hello.
How are you? What might I know? I just kind of jumped in and didn't even.
Somebody said, why? Why is Hank Brennan doing this? Is he stupid or is he being blackmailed? Don't they recognize that this trial is exposing their illegal activity and the feds are watching? She says, or he says, I just don't mean this rhetorically. I'd really love your thoughts and conjecture.
Well, I mean, first of all, by all accounts, he's a very credible, distinguished lawyer. Don't care who he represented previously. That means nothing. And remind me to go back to that because there was a funny tweet about me today and representing, so-called bad people, which makes me unscrupulous.
Right.
As opposed to, people who represented mob killers. They're heroes.
Yeah.
And why would he do it? All I can think of is like the old Indiana Jones and the Temple of Doom. Fortune and glory, kid. Fortune and glory. Lawyers who are trial lawyers, who are successful trial lawyers, and who are wired the way that people like you and me and he and others are wired. You like big cases. It's exciting. I think there ought to be discretion, and you may pick and choose better, but we don't know what's going on behind the curtain as to why he would take a case like this, apparently also for such a small pittance of a legal fee, which has to be a net loss in his career, actually. So I don't know what the hell is going on here. It's really weird.
I think plumbers are billing out at $250 an hour in New York City. I mean, this is like a really bargain basement rate.
$250 an hour is in New York City, and again, we don't want to get too localized for everybody watching, but that's not much more than what 18B lawyers would get paid. And 18B lawyers are lawyers who would get conflicts cases from legal aid. They were essentially conflict public defenders who have contracted with the city to get paid hourly. It's probably a little less than $250, but in New York City, $250 an hour is, like you said, that's not a legal fee. I'm not going to get into what, people like you and I would bill an hour,
right.
But it's a hell of a lot more than that, for sure.
It sure is. Yeah. So Romy found this Dan Linden on Twitter. So there was an email from one of the things in like the 47th or 48th exchange is this email from somebody named Daniel Linden, and we were trying to figure out who that is. So Romy found him. So let's take a look at that because this is kind of interesting. If I can figure out where I just put it. So give me a sec. This is the guy who was on Twitter talking about key cycles, which is kind of interesting. And I'm wondering, did this guy write a letter to the court? Let's take a look.
While you're looking for that, I don't put too much stock in any meaning of what they're disclosing as discovery. It seems to be that Brennan's approach is just give them everything.
Yeah.
I don't, I saw that, I don't know if he talked about this already, but he was giving reports of the famous Trooper Paul that were taken shortly after the trial.
Yep.
That he made. They were disclosing transcripts from media interviews that they're apparently culling for information, all kinds of things. More grand jury testimony that frankly Lally should have turned over before trial related to the failed attempt to indict Karen and Aiden for witness intimidation. I mean, I think he's trying to be or appear to be transparent with giving them everything. So I don't read into him dumping evidence on the defense as having any signal that this is important or I'm going to use it, as much as I'm trying to be transparent.
Right. And I mean, they had all that stuff from Gretchen Voss ahead of time, ahead of the other trial, the first trial. They
Right.
had they knew about the no true bill before the first trial even started. And didn't Lally at one point misrepresent, thank you, Romy, for doing that, misrepresent to the court that they were still investigating that? And
I think what he did was materially mislead the court by omission when he filed the motion indicating that, it is our position that the two of them conspired to intimidate witnesses. In fact, with her lawyers, so four of them really, and at a time where he knew that a month and a half or so prior that a grand jury had no bill that. So that clearly, in my view, was an ethical violation, materially misleading the court, not providing the court with all the facts necessary before making any kind of rulings or whatnot. So, yeah, I mean, I think that it's a dirty move. It's indefensible for sure.
But because of that, some of that harassment stuff came in.
Yeah, no, I think it was dirty, and one would certainly think that it was prejudicial to the defense at trial, because some of it did come in through a number of witnesses, and it kind of spiraled out of control, where you had multiple members of the McCabe family giving, teary-eyed or, so-called dramatic testimony about all the harassment and witness intimidation that they were subjected to, which there was no evidence that the defendant in the case, meaning Karen, was a part of. And the risk of the prejudice is that they associated with her, and that's the problem. And all of it was pretty bad.
Well, that's interesting now, because now that I think of it, if that was intentional by Lally, in addition to the other Michigas with the inverted Sallyport video that, he may or may not have known was inverted intentionally with the timestamp, like, he could be the subject of some bar complaints that could prevent him from retrying this case, I wonder. I mean, that's sanctionable.
Well, it's very sanctionable. I mean, certainly as it relates to the motion that was filed with the court related to the alleged witness intimidation, that clearly was materially misleading. And there's no question that was intentional. The idea that he would not know, as the prosecutor of Karen Reed, that, his defendant, for lack of a better term, had been subject to grand jury proceedings with the person he was moving to exclude from the courtroom, is zero. There's no way he didn't know that. Right. And if you're going to say it's our position that this happened, then you certainly were ethically obligated to tell the court, but not the grand jury's position, okay? Because that would carry some weight. As far as the inverted video, I mean, I suppose it's possible that he didn't know, but that's not likely. I mean, any responsible prosecutor trying a case in which you're going to offer video evidence of, the murder weapon, the vehicle, if you will, in the Sallyport with the key witnesses, that, the important state troopers, and not know that video was inverted, that strains credulity, as you like to say.
It does.
And it doesn't make any sense. And it also doesn't make any sense because his other witness, Proctor, correct me if I'm wrong, soon to be, or maybe already is, former trooper or Mr., I don't know. You get a lot of conflicting reports on that. Right. But Proctor testified, did he not, that I saw, normal video or something different. And if he saw that, how does Lally not know that? And how does he not know that the video Buchanan saw was inverted? And how does he not prep these witnesses to talk about the video? And, Buchanan seemed to get amnesia about seeing himself and Proctor a couple days later. And it just leads to the obvious, in my view, obvious conclusion that, something is amiss at the Circle K. Something's not right here between that's Bill and Ted's Excellent Adventure.
Well, we don't have Circle K in New York, but they have it in Colorado. So that
Circle K in that movie, that was in Tempe, Arizona. So, it's kind of a field trip if you're
Yeah.
in Arizona, you go, oh, that's the Circle K where strange things were afoot. But, you know, all kidding aside, how do you seriously believe that the prosecutor of a case of that nature was not aware that the video was flipped? And if that wasn't enough, you know, when the word police is spelled backwards, I don't know, that might kind of be a sign. So yeah, he could be subject to those kind of complaints. He could be a witness, and I wouldn't be surprised if they tried to make him a witness, which would also get him tossed off the team if that were the case.
Well, also, not to mention that in laying the foundation to get that video in, he questioned Buchanan, like, is this a fair and accurate representation of the way that the Sally Port looked on the day of whatever? And he said yes.
And if he never showed him that video prior to him testifying,
Yep.
There's only two possibilities. Number one, he's lying is one possibility. Or number two, there is a level of incompetence that you can't even comprehend. The idea in a case of this magnitude that you would throw up a key video like that without even showing the witness beforehand, as opposed to, I'm just going to put him on the stand and I'm going to, you know, fly without a net and hope that it comes out well. That no serious prosecutor who's experienced in trying homicide or otherwise serious cases would ever put, you know, a police officer witness to authenticate video of that magnitude without at least looking at it with him beforehand. That's impossible to believe.
Yeah. Yeah, exactly. So I don't know who this guy Daniel Linden is, but maybe he wrote an email to the court or the Commonwealth and said, listen, all your key cycle stuff is wrong. Here's why. Because it looks like whatever he put on Twitter here is an actual exhibit from court, 6/14/24. So I don't know. I guess they're just turning it over. It's part of the court file. Maybe. I don't know.
So he wrote an email to them. We don't know what it said, and he's disclosing it. I mean, that's kind of the right thing to do.
Mm-hmm.
It may even be exculpatory. I don't know. But I think, if nothing else, what the new team is trying to do is not be subject to the same criticism that the old team was, which was hiding the ball, misrepresenting, burying their head in the sand, that sort of thing. So, I mean,
You're being very kind.
You know, I'm a diplomat at heart.
Yeah. Well, what do you make of these supplemental reports? I was having a good laugh of these supplemental reports and video and photographs of Trooper Paul that were done a little over 3 weeks after the mistrial was declared. It was like they were gung-ho immediately to retry this case to the point where they sent him back out there to supplement his report. Like they were still going to move forward with him.
So the timeline is everything. And you start with the affidavit from Brennan, who I think said, I was sworn in September of 2024 and put in a notice of appearance, you know, sometime in October. So in other words, 2 months before I ever got involved in this, you know, the same team decided to, you know, tell Trooper Paul, you know, let's give another college try at what we're doing here and make this right. And he prepared a bunch of reports and God knows what. Certainly, if there are scientific reports that relate to the subject matter of the case, they ought to be disclosed. So he disclosed them. But I don't think that means for a second that they're going to use him. That would be prosecutorial malpractice to do that. I don't think a serious person who, as Brennan is, who is a former prosecutor, a skilled defense attorney, who would look at somebody like Trooper Paul and say, well, if I was cross-examining, what would I do? And then after about 30 seconds of that in your mind, you'd say, yeah, I'm not going to use this guy. But, you know, he's disclosing evidence. So he's going to let them have it. And he's going to have to just take it on the chin. He'll call a so-called real expert, I imagine. The defense will ask the real expert, if you're familiar with the work of Trooper Paul, both, you know, prior to July of 2024 and after. And do you agree with it? I'm assuming he'll say no. You know, are you aware of these things were prepared at the behest of the Commonwealth, da, 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 da. But to be clear, you know, that's not your opinion. Okay, fine, whatever. And that's that. So
are you familiar with the infamous Paul pirouette theorem, sir?
I would,
doctor.
I would bet the farm there will be a question at some point if, you know, based on your opinion, if it's possible that the impact could have been a side swipe at 24 miles an hour, you know, just hitting the edge of the arm that could have caused John O'Keefe to pirouette and, you know, land 20 or 30 feet away, whatever it was. I'm sure that will, you know, come out, and I'm sure he'll be asked, you know, if he'll be asked, what did you review in this case to come to your conclusion? And did that include any reports by Trooper Paul? Did that include any testimony from Trooper Paul? And I would imagine if they have a real expert, he'll say, yeah, of course.
And at the same time, the taillight exploded into dog tooth size and shaped pieces, which scratched his arm in such a pattern to resemble dog bites.
Polycarbonate
Yeah.
taillight at 24 miles an hour hitting human flesh and bone is not going to shatter. I mean,
it's crazy. That was his theory, and he's sticking to it. What else do you make of this? Any other thoughts? Let's see if there's any. I mean, you think she's going to grant the adjournment to April Fool's Day, coincidentally?
Maybe. I mean, I think there's kind of like a wild card here, which is she may have no choice based on what happens next week.
Right.
If the SJC grants a hearing, in other words, remands it to her, Cannone, or another judge, if they move to recuse her because she's a witness, to some judge, whether it's her or another, and orders her to do a hearing, then they'd have to call the jurors in. They have a hearing. She has to issue a whole nother decision, which could trigger a whole nother round of appeals up and down the appellate chain or whatnot. If that happens, then I think this is academic. It's the January date wouldn't happen. I think she'd have to grant it anyway to April for the simple reason that the prosecution is claiming that we have all these new experts, and the judge only has two choices. No, I preclude your new experts, or I grant time, because if they get new experts, they have to get new expert reports. And if they get new expert reports, the defense has to hire an expert to review the prosecution's expert reports.
Yep.
Potentially prepare their own reports and this and that. And the only alternative to stop that would be to preclude the prosecution from shifting gears with new experts. And does anybody seriously believe that the court is going to tell the Commonwealth that, no, I'm not going to allow you at this late hour to attempt to bring in new experts, which in theory could strengthen your case that she's guilty? So I think her hands are tied, whether it comes from the SJC or from this current application by both parties.
You saw that in the Vanity Fair piece. The reporter from Vanity Fair went out and found a Celebrite expert. She did her due diligence on that, and this guy from Purdue says that 227 search happened. It is because she didn't want to be sued, apparently, by John McCabe, and there's just another expert that the defense can put on their list, in my opinion.
I was told from the couch in Indiana that everyone's getting sued at Vanity Fair because of this.
Yeah. They're not the premier magazine for, actual investigative journalism or anything, right? Like all the Dominic Dunn pieces throughout going back 30 years and stuff.
There's no way that Vanity Fair's lawyers would have screened this and said this is okay. That would never happen. But again, when you're on the couch in Indiana, you know things more than experienced journalists and lawyers do, whatever. Yeah, I mean, obviously they got an expert who agrees that it was 227. Apparently his expertise is in Apple artifacts. I mean, who knew that was actually a field of expertise? Apparently it is. That's fascinating. I would think that if I were the defense, I would contact this person.
Right.
I would, whatever expert, whether it's the same one they're using or a different one, I would try to, figure that out, what they're saying. But either way, it seems to me, given the burden of proof, anything that makes the 227 search plausible is really all they need. And I think a lot of people, I was talking about this the other night with someone else, that they don't have to prove or win the battle of the search as much as to the prosecution has to establish it's not reasonable, it's not plausible. You have to conclude, ladies and gentlemen of the jury, that the search happened sometime after 6 a.m. If you can't prove that beyond a reasonable doubt, and it's plausible that Jennifer McCabe did it on her own at a very strange and incriminating time, that would seem to just open the floodgates to reasonable doubt and a not guilty verdict.
You would hope. Thanks, Goodmans, for calling us a great team, and for your 10, and Sassy Bartender for the 20. Sweet Jesus, Made by Night, my 2 favorite lawyers on YouTube. Thank you for your dedication to this case. We've been screaming into a closet for a long time. I'm glad you guys enjoy what we have to say. Brooklyn James, thanks for the 5. Why aren't we seeing discovery about that video and what Proctor saw? Love you both.
It's a really good question. You may remember this from months and months ago when there was first discussion about a possible retrial and, who does this favor? And I remember specifically saying that I thought one of the biggest advantages the defense would have in this several month period was to get to the bottom about the inverted video and make all kinds of subpoenas, demands, motions about it. I don't know what's happened or what hasn't happened with it. Either way, I think they're going to be much more prepared. It kind of just came out randomly. So I don't know what they've learned, but I would imagine that they are going to annihilate Buchanan and possibly Lally or anyone else, and also find out the chain of custody, for lack of a better term. They got the video that they showed Buchanan, but work backwards. How did he get it? Where did it come from? Where did it originate from? Why did it take so long? Was it originally inverted? Was it inverted? Proctor says he saw a different version. Why are people appearing and disappearing on? That is not consistent with inverted video. That's consistent with like overwriting or dubbing or other things. And I would think that they're going to be, locked and loaded on that at a retrial.
Cap cut. LA, can you normally use evidence before the other side sees it?
No.
So that inverted videos came up during the trial.
All disclaimers apply. I'm not an expert on Massachusetts procedure. In New York, certainly, and I assume other places, if that video showed up out of nowhere, mid-trial, was never disclosed to the defense, you're moving for an immediate mistrial for, what we call Rosario violations in New York, which is a failure to disclose discoverable evidence, and you'd be making a shit show beyond belief. You'd be moving for a mistrial. You'd be moving for sanctions, everything that the commenter is saying on the screen.
Brady violation, yeah.
Yeah, as it turns out, because he appears to have lied about the condition of the video. So that would make it a Brady type situation. By my recollection, that didn't really happen here. I think there was a complaint, obviously, but there wasn't an absolute, borderline stroke by the defense attorneys screaming and yelling about getting sandbagged mid-trial. This is outrageous, that sort of thing. I'm not sure why. Because
you know why? Because they, AJ and David turned into shrinking violets, or right around that point of the trial. We have no idea because everything happened at sidebar. So who knows?
That's a great point. Part of the problem with the whole transparency of this trial was everything is done at the bench. All grievances are heard privately, even though there's a record of them. She did go out of her way to make sure it wasn't an open court in the classic sense where the viewers and the public heard what was going on. And if there's an application for a mistrial, that should be in public. There's no reason that should be, and there's a First Amendment right, as you know, to a public trial. And, cases have been reversed for this, even though it has nothing to do with the litigants, but by depriving the public of information. And if there was an application for a mistrial over this kind of stuff, that should have been heard in public.
And there was also no grounds for, not to mention no speaking objections, but no grounds for objections. They couldn't stand up and say, objection, Your Honor, Brady violation. This was never turned over. This is the first we're seeing in this video. Look at this, Your Honor. It's completely inverted. It's not even the fair and accurate representation. He just suborned perjury. We heard none of that, which would have been fantastic.
During the trial, because I know there was like a day break before when this came up, and people were asking what's going to happen. And I said, what I would expect to happen the next day when they come back before the cross-examination, I would expect a defense application that will be, very sharp-elbowed, very aggressive. And unless it happened at the bench, it never happened.
We never knew about it. Albert's handcuffs. Thanks for the 20. Hi, y'all. The DeSanti Bev's decisions from trial one hold for the second trial regarding not being able to mention the federal grand jury, other bootstraps.
I mean, generally, yeah. I mean, the legal issues are decided, although, with the federal grand jury, I think that would be the same. The real issue is the ARCA stuff. I mean, there has been reporting that the jurors, or at least some of them, might have been confused and misled inadvertently by the way the judge handled that neither of these parties engaged these experts, and that some people felt either an insurance company on behalf of the defense, which is bad because that does, in essence, color the testimony allegedly, or you even heard that they thought a journalist who shall remain unnamed hired them, which is, I mean, that's crazy. I'm not sure how they would believe that, but whatever. So I would think the defense in this case would make it clear that at a minimum, the judge alter that to say, when we say that neither side had anything to do with it, that includes the parties themselves, any insurance companies, that this is somebody completely and unequivocally unassociated with either one of the parties in this case. I mean, I think that's the only way to be fair at this point, is to give a stronger explanation of what it means to say it wasn't these parties. It should include anyone associated, no insurance companies, no nothing. I mean, they ought to go that far.
Yeah, and there should be a special instruction. But again, the motions in limine could be different. She could have different rulings on those, because apparently, Hank Brennan's going to come in and try a whole new case, all new experts, all new theories, all new evidence, new Celebrite reports. The telematics system is going to magically repair itself and come up with all kinds of data.
I don't even know.
What do you think the special prosecutor is going to do with the red Solo cups?
Well, I mean, you're stuck. You got to bring the one you went with to the dance. You can't literally change the facts. You may have regret, but that's who you invited to the dance, so that's who you have to go with. So red Solo cups, leaf blowers, failure to go in the apartment, pieces of taillight which just revealed themselves weeks at a time, nasty text messages, you could go on and on, butt dials, none of this will change. So none of it.
How about they call Tom Kelleher, who was like the acting chief of the Canton PD, who gave them the red Solo cups, who lives across the street from 34 Fairview, whose ring cameras point right at 34 Fairview. And then he can also explain not only why he gave them the red Solo cups and thought that was a really good idea to collect blood evidence in snow, but also why his ring cameras didn't pick up anything.
I would be stunned if the defense didn't call him for that purpose. But also, I mean, in 2024, in a suburban county, I would say the odds are that 75% or more of the jurors are going to have ring cameras or something similar. Mm-hmm. I have them, you probably have them. Everyone has them.
Yeah. And these are cops.
And this camera, as it just turns out, is right directly where it ought to be. If you've been to that area, it's not a great distance. I mean, my ring camera can go all the way across the street. And if there's a bird chirping on my neighbor's house in the middle of the night, I'll get an alert. I mean, it really is that sensitive. And if you think for a second that a ring camera that was operable and is looking directly at the right point is not going to pick up a car, flooring it in reverse and smashing into a human being and launching him 20 to 30 feet, and pick that up, I would suggest to you that's probably impossible unless you're going to tell us and establish that the camera was not operable. But of course, the deeper analysis, and these are real lawyers, once you get past that, they will ask this guy, well, did the troopers ask you to view the Ring camera? And he's going to presumably say no. Did you show them the Ring camera? Did they just take your word, whatever it is? And it becomes less a Kelleher point and more a Proctor is corrupt point.
Mm-hmm. Yeah, good point. Misty, thanks for the 5. Why aren't more people talking about the voicemail where Jen is caught whispering on the phone to Coco?
I expect they will. I mean, there was that Microdots video about this several weeks ago. Again, why would she? Well, first of all, if she's going to call her sister, that's fine. Why would you be whispering? What's so secretive at that point? And if it was something along the line, what was it like? There's no one's come out yet or something.
Yeah, something like, you're leaving me alone out here, or I'm all alone out here,
Implies, it's not proof, but it implies prior knowledge of what's happened. And of course, for the McCabe's and the Alberts and all those people, they need to be ignorant, if you will, until they're alerted by Karen, the cops, or whomever what's happening. And that does not appear to be Jennifer McCabe doing that, on top of the alleged Google search, on top of the butt dials, on top of nobody coming out of the house. I mean, you could go on and on and on, and you get to the, if something quacks like a duck and it walks like a duck, it's usually a duck. And in this hypothetical,
Don't talk about ducks, Mark. Don't talk about ducks.
I'm going to get arrested. I know it means they're covering up something. Doesn't mean anything specific, but there ought to be nothing to cover up. Is the problem.
The totality of all of the things that are being covered up add to a whole lot of reasonable doubt.
Yeah, Scott, I mean, exactly.
Great question. Mark, when you worked for a morgue, could you pick and choose the cases, or could you refuse to try a case, or is that a Norfolk thing? Thanks, Mark.
Well, this is interesting. So,
I mean, thanks, Scott.
For a morgue, he means the old Manhattan DA is what.
Yeah, Morgenthau.
Robert Morgenthau. You would get assigned cases, obviously, but I can tell you there were times that people had issues with cases, and you would go speak to more senior people. You'd speak to supervisors, and you'd hash it out. And again, you generally came to a consensus one way or the other. Meaning, if your problems were or the issues that you were raising were valid, they would validate you and say, you know what, let's get rid of that case then. Or they would challenge you to say, well, have you thought about this? And you might say, you know what, you're right. There were rare, I suppose, very rare, infrequent circumstances where, for whatever reason, somebody may not have been the right person to prosecute, and it just gets reassigned. But to put it into what's going on in Norfolk County in a high profile homicide case. So in Manhattan, they would have what they would literally have homicide meetings in the DA's office, which would include the chief of the trial division, all of the experience, what we would call senior trial counsel, who from every bureau in the office, who handled homicide cases, who had years and years of experience. And every single time a homicide case came in Manhattan, which of course you could imagine is a lot more frequent than Dedham, Canton, and all of that. Every single homicide case that came in would be subject to one of these meetings with essentially a blue ribbon panel of the elite of the office to talk about the case, go through the facts, go through the legal issues, and you'd be challenged. There would be, again, these expert people would, what about this? How are we going to deal with this? There was always, real back and forth to make sure we're doing the right thing. And, normally in Manhattan too, they would never authorize, an arrest. It's certainly for a case like this, unless you could disprove alibi. You could, they didn't just wing it and say, the hell with it, we'll let a jury decide. In essence, you had to be, not that they'd win every case, that's impossible, but that they would be very confident that we're doing the right thing. And one thing I can be 1,000% certain about is there would never, ever be a situation in the Manhattan DA's office that if the senior brass that, of these meetings went to the district attorney, Morgenthau, and said, we don't believe this case has merit. Now, he might challenge that. He might ask the right questions. But if you think for a minute, ever in the, however many years of Morgenthau, from like 1975 to 2009, I think he was DA, would say, all of my people say this is wrong, that he would say, you know what? The hell with all of you. You're all wrong. I'm right. I'm going to get on the horn at taxpayer expense and find somebody on the outside who's with me. The hell with all of you. So the answer is that would never, ever happen. And if that's what happened here, then you have a dysfunctional DA's office at a level that, as awful as you might have thought it was a few weeks ago or before you read the Vanity Fair article, it's got to be chaos beyond belief in that office if everyone to a man and woman said this is wrong for whatever reason, whether they thought she was innocent, whether they thought she was not guilty, whether they thought the cops were corrupt, whether it's just not worth it, whatever. I've never seen a situation where the elected official basically says, well, you're all wrong. Never mind. I'm going outside. And, it may not be coincidence that in the span of a couple of weeks, the first ADA bailed, the press person bailed. Who knows? Are they related? Maybe, maybe not. But this is an office that is in complete chaos, if that's what Vanity Fair reported is true.
Yeah, it's like Brennan got the hot potato because nobody else wanted it. It's bizarre.
And he wanted
conflict,
a fraction of market value for somebody like him, which is, it's odd. I mean, look, maybe he's doing the taxpayers a break, but it's weird. There's no question.
Thanks, Piney Woods. I'm not at all worried about Ms. Reed's defense. I think they're excellent too. Iceman, Columbo trivia episode Double Shock with actor from one of my favorite shows as a kid where he met his wife, actor and plot.
Okay. So it's Martin Landau, first of all, and he's playing twin brothers who murder their uncle because they were kind of left out of his will. And one of them is a degenerate gambler banker. The other, Martin Landau, is like a television celebrity chef, and he murders him by putting an electric mixer in the bathtub with him. Also in that is playing his young bride is Julie Newmar, who you may know as Catwoman from the old Batman. So how's that for Double Shock?
Wow. Well done. Well done. I had no idea that you were such a Columbo fan. Thank you, Iceman, for the challenge.
Favorite old TV show. Breaking Bad and Better Call Saul are still, but Columbo I watch all the time. I got that from my dad.
Yeah. Lisa, thanks. Would Brennan be forced to file the email about the key cycles if that guy sent the email to both the Commonwealth and the defense? Yep. Because it seems to go against the Commonwealth's case.
Well, if he sent it to the defense, then no, in a literal sense, because the defense had it. If he sent it to the Commonwealth and he's alleging exculpatory information that lands in their desk, then yeah, I mean, the better practice is to disclose it as Brady. But I mean,
they're just exchanging it though. He's not filing it with the court at this point. It's because it was always already marked as an exhibit in the first trial, but then whatever this email is, they're exchanging with the other side because he may not know whether or not it was sent to the defense also. So
yeah, I would think that the discovery itself is the substance of the email more than the exhibit. I mean, the exhibit both sides had access to clearly. I mean, in the picture you showed, it's literally an entered exhibit.
Yeah. Thanks, Lisa. Thanks, Christine, for liking us and for your super chat. Wasn't there two types of blood swabs found on John O'Keefe's pants? If so, did they test both or get DNA samples from everyone at the house? You guys the best?
No, because in order to get a DNA match, you need a sufficient concentration of DNA. And by my recollection, they found, I think, a mixture. A mixture is just a term of art, meaning there's a pile of DNA with multiple people, and there are a majority contributor, meaning, one person had the most, and then minority contributors. And John O'Keefe obviously was the majority. It's his clothes, his blood. And I think they found two other people's.
Some of them had two unknown male contributors.
Right.
Some of them had 3 unknown male contributors, as I recall.
The problem is it was an insufficient concentration to do testing, which means at that point, the judge is not going to authorize taking other people's DNA to test it because, I mean, that's the most intrusive form of search, obviously protected by the Fourth Amendment. I mean, it's somebody's genetic material. Courts are very careful. And if, by all accounts, there's no possibility of matching the DNA, then most courts, this is not a Cannone thing, are going to say, I'm not going to give you their DNA if you're already telling me it's not matchable. So if what they would do is they would say there's, John O'Keefe's DNA, and then there's like male donor A would be one of the mixtures, and male donor B. Those are unknown people. We have a sufficient DNA profile that is suitable for testing. I think at that point, the defense would have had a very credible argument to say, you got to test Colin Albert, Brian Higgins, those kinds of people, and see if they come back matching male donor A or B. And of course, if they did, that would be a home run. But apparently the testimony at trial was it was not enough DNA to even make a comparison. So I think that's why she didn't authorize taking their DNA.
I will take your word for it because I don't recall that part of the testimony, but I do recall that in pretrial, they had a hell of a time just getting Google search records and Jen McCabe's phone records and Brian Albert's phone records, but they did get buccal swabs of Proctor and Buchanan to rule out. So they did have those samples, but they didn't get them they weren't going to be able to get them from anybody in the house.
It is common when you have people who corrupt the crime scene. Corrupt may be too strong a word.
Right.
Elimination samples. So,
but they had a fight for that.
Right. But it's not uncommon in a normal case, which I recognize this
right.
is not.
That they just get it.
That they would test the cops to essentially eliminate them as the suspicious DNA. But in this particular case, it did seem weird that they were going out of their way to say, it ain't me, babe.
right. Even better. Shaggy too. Diane, thanks for gifting 5 memberships. I appreciate you so much. Deanna Bellina, thanks for the 5. If Kelleher's video didn't catch Karen, wouldn't that be just as critical to seeking actual justice? Yeah.
It's
absence of evidence.
It's in fact unfathomable that the Ring camera would not have seen the cars pull up, the people get out. Again, it doesn't have to be the accident. Did John O'Keefe get out? Did he not? Did she go in reverse? Did the other people walk by? Who knows? The other thing is this. What if the Ring video showed, what one of the witnesses described as, the blob on the lawn?
Mm-hmm.
It's not just the accident. If it was visible on the Ring camera, that would be, pretty compelling when all these witnesses say, I didn't see it. When we pulled out, put our headlights on, which would have blasted right on the lawn by the flagpole area, generally speaking, where John O'Keefe would have been. So the fact that nobody even sought to see the Ring video, add in the missing library video, add in the missing Ring video from John O'Keefe's house, blah, 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 blah. And, you can see how a reasonable doubt argument on a shoddy police investigation with everything else becomes pretty powerful.
Yeah. Why doesn't the defense get a subpoena for the Ring footage? Well, they're sure the retention policy is far expired by now. Did they ever try to? I don't recall.
Don't know.
I remember there was some talk about the Nest footage because Brian Albert told somebody that he had a Nest camera that he got for Christmas, but he never put it up. I don't recall whatever happened there.
Maybe, but
maybe they brought Brennan in to mentor Lally.
I don't think so.
I'm sure Lally's not happy about it. Do you think Lally's gone? I haven't seen him file anything recently, and he didn't even sign the most recent documents. Says Furious.
I don't know. Again, to me, he's a potential defense witness on the video, so I don't even know what they're doing with him.
Yeah, it's the PR crisis over there at the Norfolk DA's office and the MSP both are so crazy that, these people are working overtime just in trying to put out all these fires on a daily basis that it's hard to know what's real and what's not, and what they're trying to squash right away, and what's really going to happen, and whether Cannone's really going to be rotated out of there in the end, because maybe they're trying to squash that because it was a really bad week. The day your bomb letters dropped, I mean, that week that you dropped all those bombs on that office with, their selection of not so confidential informants and, personal email servers being used to communicate with judges to try and strong arm them into giving out restraining orders, which then he actually did do. And, so many things, texting with, lay people who may or may not be, part of the mod squad. The whole thing was bizarre, and they had to put out a lot of fires. And perhaps the last thing they wanted to admit was that, yes, indeed, in fact, Cannone is going to be rotated off this case.
Yeah.
That's just my opinion. You don't even have to comment. You can just sit there and look cute. Romy, thanks for the 10. Yesterday at my daughter's hockey game, someone I don't know handed me a beautiful tiny glass duck. Thank you, whoever you are. Oh, that's very sweet, Romy. And whoever gave you that duck. Botanist Gaming, how would this delay affect the civil trial if granted? Didn't judge grant a delay in defense discovery under presumption of January retrial? It was a 6-month stay, only with regard to Karen and her deposition. So
And it would be extended because the logic doesn't change. Truth and logic. And that what we're told is the important part in analyzing, at least from the attic, we're told truth and logic. The issue here is her Fifth Amendment right not to incriminate herself and to assert her right, her Fifth Amendment right to remain silent. And if the criminal judge adjourns the criminal case for valid reasons, whether it be because the Supreme Judicial Court sends for a hearing or the judge finds that they're still in discovery, the civil judge is not going to come back and say, well, you know what? I'm no longer concerned about her Fifth Amendment right. We need, let's get moving. Let's get this on. So no, the answer is there's no way they're ever taking her deposition until the criminal case is over. It's just not going to happen. It was never going to happen. I don't know why, and I know when they filed that motion and talked about weaponizing.
Right.
I mean, that was bluster for the public. That was never, this more than me. You're the civil litigator expert. That was never going to happen.
I had secondhand embarrassment for the argument that they got up to make in front of that civil judge. Well, she's been talking to the press voluntarily and tainting the jury pool. Therefore, she should waive her Fifth Amendment. Okay, that's not how it works. Yeah. Number one. Number two, sit down. Number three, a delay of the criminal trial, in my opinion, as a civil litigator, is great for Karen Reed's civil defense because the judge is now going to say, okay, you guys wanted discovery moving, right? You wanted this thing moving. Respond to the interrogatories, give them a bill of particulars, respond to all the defense's discovery demands. And by the way, plaintiffs are always deposed first in civil cases. So, okay, Mr. and Mrs. O'Keefe and Paul, you're going to have to be deposed. Let's pick dates for your depositions. I'm going to court order it. And all those depositions will be held, in my mind, prior to April Fool's Day. And they're going to have all those transcripts to use to impeach them at trial. And who knows, maybe they'll call Mr. and Mrs. O'Keefe this time. We don't know, but that falls under, you better want what you wish for. Because if you really wanted this discovery to get moving, okay, move it.
I never understood that lawsuit.
I like to move it. Most ring bells are in a cloud. Can they subpoena? I don't know. Kimmy, I think the retention policy on that stuff is short. I think it's like 90 days or 6 months or whatever it is. Proctor waited for it to expire before he subpoenaed it. I know that.
I don't know, but the problem here for the DA is they have the burden of proof. They didn't preserve it. They didn't present what should have been relevant evidence. This is, of course, the defense would like to see what it is, but this is a Commonwealth problem. They have the burden of proof, and part of a reasonable doubt argument is how pathetic and or corrupt the police investigation was. And, when the soon to be fired, if not already fired, disgraced lead investigator testifies as a defense witness and tries to repeat how straight this case was and how I was just, laser focused to get the girl. She did it.
Yep.
But I didn't need to knock on the door. I didn't need to look at ring camera. I didn't need to do this. That's a DA problem. Okay. So if that fact were to come out, that's a question the defense would be asking Proctor. Are you aware in your experience how long this video could have lasted and what steps, if any, did you take did you take to preserve that? I mean, did that, as an investigator, was this a curious fact for you? You know, this could have laid bare the whole case, right?
Mhm.
This could have
Right.
literally given you, that's Lola having kennel cough in the background.
Hi, Lola.
If you hear her hacking, she's fine. It's just a little kennel cough. But they didn't do it. And Proctor, as the, you know, the ace investigator, if you will, who told you, I contacted Ring about the Meadows video, will be asked, well, why didn't you ask them about that video on Fairview Road? So
You know what I might do? I might call in every single neighbor on the route that Karen took out of One Meadows. Away from 34, for every single neighbor, I would have bring them in to testify. Did anybody ever knock on your door? Did anybody ever ask to see any of your Ring camera footage from January 29th or 28th of 20? It was 29th because after midnight of 2022. Bring every single person in there to say, no, nobody ever asked me.
well, you know what the
Because
answer will be? It won't be no one had ever asked me. It'll be, well, yeah, several months later, a journalist did.
yes, yes, because any of their Ring camera video would have shown her leaving the scene, would have shown whether her taillight was broken, potentially exculpatory, but none of them were ever asked. I mean,
They didn't want to know.
thanks, Maura. Yeah.
They just didn't want to know.
But initially they told the press, investigators have Ring camera footage of the incident. Thanks, Stephanie, for becoming a member.
It's troubling for sure.
Romy, they never test the red Solo Cup blood, correct? I remember Maureen Hartnett testifying it wasn't tested. Why wouldn't that be swabbed and tested? That's right. She did not test it, I think. I believe that she did not test that.
I assume that they just, and assume is never a good word to use when you're talking about science and crime scenes. I get it. But that they assumed it was just John O'Keefe's and, you know, we're done here. What's for dinner?
Or if she did test it, she'd put the same swab into every single cup. Or if she did test it, she tested only one cup. Yeah, that's what it was. Only one cup.
Yep.
One test. Yeah, that's what it was. She didn't test them all. Kind of like when they swabbed all of the dog teeth marks. They only, they took one swab and did them all. They were not individual. Hi, Suze. The buccal swabs were for the DNA on the back quarter panel, only given to Mass Crime Lab. They were not sent to Bodie Labs. Can't remember if Bodie said there was enough other DNA for testing.
I don't remember.
From the jeans. Yeah, I don't remember from his clothing. Sebastian, what's your thoughts on the defense trying to use John O'Keefe's phone movements the morning he was discovered? Does that prove third-party involvement and further prove Karen Reed's innocence?
Well, I mean, if they have credible evidence that his Apple Health data has him going up and down and moving around at a time that the DA alleges he's already been struck and killed, that can only mean one of two things: that he was not hit, was not struck and killed, and was going up and down, which, of course, if he's going up and down, there's only one place he could have been going up and down, inside the house. Or the only other alternative is that somebody else had his phone, which is equally incriminating at that point because they don't know what happened to him. So,
right. And they were waving it around, maybe, or going up and down a hill in their car with it.
I look, I don't know what the logistics are of this, of getting an expert to talk about how Apple Health data works. But as somebody who's had an iPhone for too long to even remember, and an Apple Watch for probably what feels like almost 10 years, and who actually monitors my steps and all of that kind of stuff, there are times where I'll go up and down real steps and say, where the hell am I, where are my stairs? I'm not getting credit. And it's kind of a delayed reaction that comes later. But one thing I'm pretty sure has never happened is going in a car, up a slight incline where I say, oh, look at that. They think I've got stairs. I mean, the watch, I think, is designed to factor in heart rate and movement and arm movement and all of that. I don't know what the algorithm is to actually give you credit for a flight of steps, but I'm pretty sure it's not sitting in a freaking car going up a minor incline at a calm, resting, doing nothing position. And if the argument was, well, he's holding his phone like this, yeah, that's not going to do it either.
It was just it was laughable at that point. Nilka Nico says, thank you, Sebastian. Canton police did knock door to door on the route. My sister is in the route. They said they're looking for robberies. They asked your sister for actual ring cam footage.
Hmm.
That's interesting.
They've never answered the library question either, which is just beyond belief to me that it just happens to be missing the 2 minutes where she would have gone whizzing by.
Yeah. Thank you, Marcello, for tuning in from Argentina. I think a lot of people are worried mostly for potential jurors because the last jury explanations we got were insane.
Juries are always, juries. There's always risk. I'm a big proponent of bench trials when you have an open and shut case, legally speaking, although
Right.
this is complicated for other reasons. I get it.
Yeah. It's a mess when Mark Bederow utters the S show word. Speaking of Trooper Paul, says Dewey as well, regarding not putting the tail out of the law, my favorite comedy moment was, well, you didn't. That was pretty funny. Did you sprinkle it? And then I think Alan Jackson said, well, you didn't, or something like that. That was great. Morris from Stoughton. So sad to see the corruption. Love my town. Hate what's happening around us. Also love listening to the both of you. When are you up there? Brother Mark, would you take it? Would you take this case to prosecute?
No, of course not.
Brother Mark, my brother?
No, I think it's a horrible prosecution for a lot of reasons. I wouldn't believe a lot of the key prosecution witnesses. I would ethically believe I'm suborning perjury. I don't believe there's any credible evidence to get around that. I think there are insurmountable hurdles to get over, whether it be archetype stuff or some of the Celebrite type evidence. But even beyond that, I don't know what serious prosecutor who's been around the block and takes their job seriously is going to accept the fact when Buchanan and Proctor and Berkowitz or whoever look you in the face and say, this is how we found the taillight. Like, for real, no shit. I'm telling you what happened. And I think a real prosecutor, which no one really did at the trial, certainly not Lally as the prosecutor, would have said, well, when you found the first piece at night and you knew the taillight was, I don't know, 80% gone, 70% gone.
Oh, yeah, all of it.
And the piece you found is about, 2%. And there's a piece right there. Why wouldn't you have said, keep digging? Like, it's here. And if it was too dark, why wouldn't you come out the next day in daylight with twice as many people and say, dig right here until you find it? It has to be here. Moreover, when they miraculously found the other taillight pieces,
just revealed itself.
When they found the first piece that revealed itself, I don't know why that day you wouldn't have said, send a team or give me a shovel. I'm going to dig and find it all. It happened the second day. I mean, I could do this again and again. Why they didn't do it. And by the time you get to the 10th day, I mean, who believes this? I mean, who seriously believes that's how the taillight was found? I mean, I can't accept that. It strikes me as literally impossible. And just, if it's true that these police officers are just pathetic to a level that you just can't believe, to the point where they're just not credible. They're not telling the truth about that.
And why is it that nobody that lived at the house found the taillight? Why is it that it took these guys going to and from work? Because, that's what he told his guys. He's like, drive back and forth on your way to work and home, drive by 34 just to see if any more stuff reveals itself. Just in case.
Mind you,
and he testified to that. That's what he told them to do.
You don't even know how that taillight got there and who put it there day after day. I mean, there was that other testimony about, oh, they're digging in the Asian guy's house. We don't know what that means. Could that be, oh shit, they're getting too close? Or could that mean these dopes are in the wrong place? We put it over here. Like, they're digging in the wrong place. Dummies, move over 30 feet. I don't know. I mean, you can speculate about it all you want, but none of this makes any sense. And I don't know
Matt McCabe.
Any serious prosecutor who would accept these answers. It's just mind-boggling to me.
It's I have secondhand embarrassment, for real.
Yep.
Nancy's curious about what's in the pool they filled in. Thanks, Nancy, for the 20. That was, I think, one of the Albert brothers filled in his pool. So there was some speculation about what was in there. I don't know either. Robin, they never checked cameras between One Meadows and her parents' house either, or had the Dighton cop confirm that the light didn't look like they showed. Yeah, I was wondering why there was no cross of that Dighton police officer. I don't think there was a cross.
There was no cross.
Wait, he was a defense witness?
He was a prosecution.
He's a prosecution witness, right? And he was never asked,
It's fascinating. So he's a prosecution witness who, in essence, gives exculpatory testimony, and the defense asked no questions. I mean, it was, it was like he came from the upside down. None of this made any sense.
Right. Like, I would have had him describe it better. Like when you say there was a little crack in it or a little piece missing, can you elaborate on that?
The only thing I can speculate is that the defense didn't have a chance to fully interview him, and they got a good answer, and by not crossing, they made damn sure it stayed there.
Yeah, and didn't know what he was going to say or what he might have said. I don't know.
They're clever, intelligent people, so they clearly had a reason not to do it. Having said that, it was...
He probably also wouldn't speak to them at the trial, so it wasn't like they could send their investigator to get a statement from him, right?
Right, and there's, you want to be careful about not asking things you may not get the answer you want. So when he said it was just an indented taillight and it wasn't consistent with what Proctor was saying, from their standpoint, that might have been enough. Now, at a second trial, there might be some difference there.
And they don't get criminal depositions in Massachusetts. This Delphi trial is wild. They did like 70 pre-trial depositions in this criminal case. Like every investigator was deposed, every FBI agent. It's crazy. Nicole says, if you were Hank, what would you do?
Run away as fast as I can and go back to making lots of money and being consistent with these interviews I've seen you say about, if cops are lying or the evidence doesn't support it, you can't do it. Now, I don't fault him for doing what he's doing, but I don't know why he's doing this, giving up what appears to be, or what we're told is a successful criminal practice, to almost certainly lose a very high profile criminal case, sacrifice tons of money, and just get stuck in this mess. And frankly, as a reputable criminal attorney, I don't know why you would ever want to be associated with somebody like Michael Morrissey at all. I mean, it's not a good affiliation, right? I mean, so I don't know what's going on. I don't know why he's doing this. I don't really care. I mean, he's supposedly a very good lawyer, and it's a big case. I get it. I good for him. Would I do it? If I were him, I would run away as fast as I can and say thanks, but no thanks. But to each their own.
What about the statement that Chris and Julie were at the house? Yeah, I pointed that out the other day, and then somebody ran with it on Twitter, which I was happy about. They had the receipt on that. But Chris Adams' original statement said, we followed back to 34 Fairview. I mean, I remember that from the pretrial stuff I did.
I remember that, and I don't know why that wasn't drilled down deeper. And if nothing else, it's a win-win. Either they're lying and they were there, they're not there, then you're just exposing Proctor and Buchanan as illiterate dopes who don't know how to take a statement. I mean, it's kind of a big thing you wrote there, that they went back to the house. Of course, correct me if I'm wrong, these guys prepare reports that basically merge statements of multiple witnesses into one report as a combined thing.
Yeah, and Chris and Julie were, interviewed together.
Scott, the former NYPD, and all of them about the idea of preparing a DD5 that, in essence, that's a detective report in New York, about merging multiple statements into one report and not attributing who said what. That is a failure in investigation 101 and just pathetic police work.
And that's very kind. Pathetic is being very kind. Could Hank back out now, or is he stuck? I mean, he took the money, he signed the contract. He's on retainer until June, I think, June or July of next year.
If he backed out now and he said, I can't in good conscience continue based upon what I've seen, and I'll return prorated money, I think he comes out a winner. I don't think he's going to do that. I think he's down the rabbit hole, and he's going to have to try to punch his way out and at least look credible. again, if you want to be the guy who made a living out of, cross-examining vigorously police officers or federal agents, even more on point as being lying and ridiculous, and then a few years later want to argue that Michael Proctor and Buchanan and Tully are credible witnesses. I mean, you're allowed to do it, but doesn't strike me as very credible. So in that sense, I think he's stuck. Again, you got to go to the dance with the one you brung, and these terrible witnesses are what he's stuck with, and that's not going to get fixed by finding a telematics expert on the internet. That doesn't fix that.
It seems like he's just trying to start a whole new case and just start all over, and we'll see how it works out for him. I mean, I'm here for it.
Yeah, I mean, you got to respect his skill level. I mean, I've never heard anybody say he's unethical or anything like that. I don't know why he's doing it, but I mean, I don't go in assuming he's corrupt. I don't assume he's a bad guy. I don't assume he's a bad lawyer. We'll just have to wait and see what he does, and then you'll call it the way you see it. But nobody has suggested that he's suppressed any evidence or ignored anything. I mean, he's going into this with his eyes wide open, which is the crazy part to me.
Unless he knows some better experts that are going to come in and have a completely different theory than Trooper Paul. But even still,
I don't know how to fix it.
It benefits the defense to get a second bite at this apple, because everyone's been paying attention to what we're all talking about out here on YouTube, and all the questions that you guys are asking, and all the things. You guys are the mirror jury. So all of the questions that you're asking and all of the things that you want to have explained are all, the defense is watching. Both sides are watching, and they're going to hammer home all the points that you're bringing up next time. Like this one about the CERT team, Romy. I mean, that's a great point. Why couldn't they do Google Earth? I don't know how admissible that stuff is. 1 year to the day you can search. Could they introduce it? If at 12:45 a.m. no body, then at 3 a.m. there's a body?
I don't know how reliable Google Earth is. I mean, I know what it is, obviously. I don't know how frequently they update it, or how, if you could literally hone in on the front yard at that time. I mean, if you could, then that's an interesting point. I don't know if that's possible or not.
If you could, they'd probably do that in every single case, every single criminal case, right?
Well, that's true.
I mean,
really Orwellian, by the way. If you could literally see any single person at any given time doing any given thing, I mean, that raises other issues, perhaps.
Well, we're being watched all the time anyway. I mean, let's just face it. We've got a tracker in our pocket at all times. It's come to the point where now, if your phone does not move for 9 hours, it's assumed that you committed a crime and you left your phone home.
Right.
I mean, that's what is going on in Delphi. Here's two questions that go together. Thanks, Furious, for the 10 tinfoil hat time, but hear me out. Technically, could Brennan be a federal plant? Legally, would that be allowed? Maybe I've been watching too many FBI mob documentaries. And then Tara says, do you think Brennan owes Marcy something, or Marcy has dirt on him?
Okay. He's not a plant. That's I mean, look, do they have a prior relationship? Well, Morrissey is a, Norfolk County, Massachusetts legislature career hack who has had nothing but a government paycheck for the better part of 20 or 30 years, and apparently was very close to Billy Bulger, who everyone knows was the brother of Whitey Bulger and was the head of the Massachusetts legislature, and basically ran the state as the political hack. And only in Massachusetts would the brother of the mob boss be, a good Democrat politician to lead the state. Eventually, I think it was the 1990s. This is very local, I get it. But everybody knows there was a period of time where Whitey Bulger was on the lam and nobody knew where he was. And the federal government very strongly believed that brother Billy knew exactly where he was and was not cooperating with law enforcement, and he's running the state. And this is a terrible thing. And eventually they ran Billy Bulger out of politics for this. But naturally, because it's Massachusetts, what they did was give him, a cushion landing. If I recall correctly, we're going to give you the presidency of the University of Massachusetts, I think it was, to say, because you're such a loyal person. So now here comes Brennan, who represents, brother Whitey, to, someone. So is that a connection? I don't know. It's all incestuous in, hack politics that are controlled by one party, whatever party it is. It's the way it is. I don't know if there's dirt. It could be just they're friendly. It could be he trusts him because, you represented a guy that I was friendly with, his brother. I don't know. It could be he thinks you're a good lawyer and willing to prosecute a case because no one in my office will. None of this makes any sense. But what's astounding to me is that the journalists don't ask the questions. All they do is report that, hey, Whitey Bulger's lawyer is coming in to prosecute Karen Reed. That's interesting. When the real story is, why is this happening?
Mhm.
Why is a DA's office that has 40 or 50 lawyers not using their own taxpayer-funded attorneys, and you're now charging taxpayers with additional money when there's no conflict of interest? They're not saying there's one. Why
Yeah.
now on, if you count, Mello, Cosgrove, and now Brennan, our third extra prosecutor in this whole sordid circus.
Right.
I mean, this doesn't happen anywhere else, not to this level.
Yeah.
So where is the media to ask the real questions? Why?
Mello, Cosgrove, Brennan. Right? That's
Yeah.
3.
But I think Brennan in particular, because they're not alleging there's a conflict. They're just bringing, this is not a disparaging comment on him. This is just a factual statement. He's a ringer. They had to bring in a ringer.
Where's Mello? Do we have proof of life? Do we know? What happened to Mello Yellow? Like, where is he?
Well, we have a hearing scheduled in January.
I'm waiting. It's on my calendar.
We expect him and others to testify, unless we're told differently that they declined to for whatever reason. And I don't know. We'll see.
But do we have proof of life? Do we know that he's still among, the living? I'm concerned.
I think so.
Kind of disappeared.
I don't know.
Michael Marcy hung out with Whitey and crew at Marina Bay back in the day, says Nico. Speaking of mobsters, did you know that Sammy the Bull has a YouTube channel with like 500,000 subscribers? And that as recently as like 2 days ago, he's posting videos that get like 250,000 views. Like, it's insane. He's at the Trump rally. It's like out there. Sammy the Bull, 79 years old.
Anyone who is
done.
Even a former mobster, they're always going to be creative on ways to raise money. And a good mobster, rolls with the time and the changes. And yesterday it used to be breaking kneecaps, collecting money, shooting people. Why would I do that when I can raise probably triple the money by having a YouTube channel and say it's Sammy the Bull, and there you go. So that's capitalism.
Yeah. Deirdre is pointing out that Google Earth is not that accurate. Painted a house a year ago. Google Earth has. Yeah, agreed. Yeah. What do you think the SJC outcome will be? Listen, this is like, would you put a bet on it? Would you bet $10,000 that it was going to go one way or the other? I don't think I would bet. I'm not.
I wouldn't bet, but I wouldn't be surprised if they send it back for a hearing.
I think so too. I think
right outcome. I do.
Yeah. I mean, based on the ACLU brief, which, whether you put a lot of credence into it or not, them coming into this, they had to go out and they had to cite a lot of cases from other states, because listen, if these cases don't exist in Massachusetts, maybe it's time to change the law.
Well,
and maybe it's time to make some precedent instead of just hiding behind the fact that there are no cases that address this specific issue.
That's the beauty of the American common law system. There's no precedent on this. So it is certainly in Massachusetts a case of first impression.
Mm-hmm.
It's interesting too. Massachusetts is a state where they do frequently rely on state law, to give
only
more rights than the U.S. Constitution. They can't lessen an individual's rights, but of course, a state court can apply state law to expand an individual's rights against the government. In other words, make the double jeopardy or Massachusetts equivalent of double jeopardy more powerful. And I've always thought the right thing here from day one was not to grant her a win right away, to have a hearing, take evidence, make the findings. Was she really acquitted? And if the 12 jurors say that, and then I think the fair question is, well, why the hell didn't you people tell me she was acquitted, and then there'll be an answer for that. And based on that, a judge would have to make a ruling. But to do it the way she did it, I thought was wrong.
Thanks, Kim. Yep. It's easily curable. How about moving forward? Moving forward, judges are required. They have a little handbook. These judges, they have a little handbook telling them how they should handle things such as like this. And how about like when there's multiple counts, and the jury comes back and tells you that they are hung, you are to inquire of them whether they are hung on all charges.
Wow,
and
that's a really good
that would
point.
just be
When a high court of a state is going to rule on cases like this, they like to draw clear lines for future cases. They don't like to just rule on a very narrow one case and want to revisit this issue again and again. And I think you just put your finger on the real reason that they may very well do this, is to send a message to every judge in the state that whatever you've done in the past, the law of this state is very clear. When there is a multi-count case and a jury comes back and says, we can't reach a verdict, the law of this state requires the trial court judge to say, what does that mean? Which count? Have you reached a count on anything? And if you want to get the lower courts to pay attention, then what you do is you rule on a high profile murder case and say, we're not going to tolerate this. We're going to throw it back and make sure that everybody understands that's what you do. And I think that would make me nervous if I were the DA here, is that this is ripe for the high court to take out the ruler and smack the lower court on the wrist and just say, come on, ask the freaking question. If you ask the question, we wouldn't even be here dealing with this.
Come on, man.
Yeah.
Mimi says that we now know Bev's brother defending Chris Albert in his drinking and driving incident. Well, they knew that before the trial, actually. Can that be used as a conflict to prohibit her from presiding?
One of the things, I mean, it's already been heard. One of the things that jumped out at me in the Vanity Fair thing was how, the alternates, which of course, as you know, in New York, they just get picked right away. I mean, before the trial, you know who they are. There's no scandal here. But when they, wheeled it out, if you will, with the little thing to pick the alternates, it was the clerk of court and no witnesses. That's crazy.
It was Jim. It was Jim. Who it's apparently may or may not have been involved in some other type of.
I don't know. I'm not gonna, obviously
I don't know.
Clerk of the court, but given the allegations in this case, and given the allegations involving Chris Albert, given the allegations who Chris Albert's lawyer was related to the trial judge in her case, the idea that they would draw the alternates without representatives from both sides to just say, okay, here's the person, do it again, here's the person. Why wouldn't you do that?
I thought we watched that together and we were like, what are they doing? First, she picks the foreman first, and then he spins the wheel. Nobody ever got to look in there, make sure all the numbered the little lotto balls are in there. And then he just picks them up and he doesn't show it to anybody. It was bizarre.
They do nothing to avoid the appearance. I'm not saying they fixed it. I don't know.
But
why would you not do it in a transparent way so that people like us and others are not talking about this, saying, did they fix it? I don't know. I doubt it, but I don't know. It looks terrible.
The appearance of propriety is like something that should be paramount in every courtroom across the nation. And so on that note, are you paying attention to Delphi, which you want to talk about like a closed courtroom, only the media can view the exhibits at the end of the day. The public cannot, and it's insane.
Contrary to what, all my, Twitter lawyer, law degree, and grifting friends who attack on a constant basis. No, I haven't been taking, I've heard of it. I see some stories, but believe it or not, I work.
You have a day job, yes.
I really do. I definitely have a very high.
I try and tell people. I try and tell them. You're very busy.
I am. But I'm not like literally up to date on every single true crime case. There are some that I could be, I guess, but I don't know much about it other than, it's kind of a half a scandalous case, but did he do it or not do it? I have no idea. I don't know the particulars. I know it's a horrible case of two young girls who were savagely slashed up near some railroad tracks in Indiana or something. Beyond that, I did see, I mean, I certainly respect her opinion a lot. You know, Andrea, who's, you know, well, legal analyst, appears to be outraged about the case, which piques my interest because I value her input and opinion. She's brilliant. But even then, I don't know anything at all about it.
Well, let me just tell you a little something and tell me what you think about this. Richard Allen is arrested almost 6 years after the crime. And pre-trial, he is placed in a maximum security prison for 13 months in solitary confinement.
Prison or jail?
Prison.
Pre-trial.
Pre-trial. For 13 months, guarded 24/7, lights on 24/7, injected with Haldol, not allowed to, he saw his wife twice in 13 months. Defense is making all kinds of motions to move him out of there. Why is he in solitary? What? In the hole for 13 months. After 6 months.
Is in these conditions?
What?
Are you going to tell me he confesses in these conditions?
Yes. After he was forcibly given Haldol, after the first 6 months, when the psychiatrist or psychologist assigned to him in the prison now, he has lost 40, 50 pounds. He starts hallucinating. She is a true crime junkie who is watching for the past 5 or 6 years YouTubers talk about the Delphi case, and admits on the stand that when she met with him every day, she would talk to him about what people were saying about his case on the internet.
It all be suppressed as involuntary, clearly.
Well,
it's not.
Jury's hearing all about it.
That'll get reversed.
The judge is not allowing the public to see any of the exhibits. Andrea made a motion to the Indiana Supreme Court, a writ of mandamus. She filed a writ of mandamus to force the judge to release the audio transcripts. This would blow your mind. What the third party culprits that the FBI investigated, the FBI was thrown off the case. I mean, the treatment that this man, whether you think he's guilty or not, the inhuman, cruel torture that he was subjected to for 13 months in a maximum security prison where no one in Indiana state history was ever, after conviction in this ward, spent more than 30 days in solitary. This man was subjected to for 13 months.
Confessions are important, like due to a lack of other credible evidence, it'll get reversed. But I mean, that's going to cost him years, obviously, before that happens. But yeah,
been there for 2.
I don't know, again, guilty or not, that's ridiculous.
Yeah, it just doesn't happen, right?
No, that's crazy.
So yeah, we needed your validation on that to make us think that, again, we're not crazy.
No, that's horrible. I mean, that is classic involuntary. I mean, in those conditions, anyone would say anything to attempt to get out of that. And of course, with the hallucinations and all that.
They were videotaping him 24/7. They used a camcorder to tape record his lawyer visits.
Well,
they have video of him eating his own feces and smearing his feces all over his face, banging his head against the wall all day long until he was like bloody, like drinking toilet water. Like he was treated worse than a prisoner of war. It's
that's that'll get, if he's convicted, that'll get reversed.
Yeah, well, we'll see.
No,
I don't have a whole lot of faith in juries anymore. I mean, this is just such a human rights issue.
No appellate court, even in Indiana, for those who live in Indiana, would put up with that.
Well, you would have thought the feds would have stepped in on this one, but you know.
Yeah, no, that's a good point. I mean, that's really serious violations. You don't usually hear people talk about like Eighth Amendment violations. That this would be that. I mean, there is a cruel and unusual component to that too. It's
a rabbit hole. But when people say, "Where's Mark? Why won't he come on and talk with you about this?" I'm like, "Well, he has a day job, you guys." So as much as I love having you, I understand that you're very busy.
Never really paid attention to it, other than coming across some comments about it.
Tell us when your next hearing is that we can watch on television, or Aiden, or anyone really. We'll watch you do anything at this point.
We have an appearance in November 1st, which is a pretrial conference for the district court case. The lower case, the alleged violation of the harassment protection order, as they call it there. Then we have a hearing on December 2nd the purpose of which at the time in September when we appeared was to address a motion to suppress evidence that was going to be from a search warrant under the theory that cell phones, as we were being told, were never searched. Well, that landscape, as you know, has changed because and I'm only saying this because it's in the public record already, we have presented proof that's public that cell phones were searched almost instantaneously after they were seized and had been searched for a year ago. So that will be interesting to address. Then we have an appearance in January, which is supposed to be an evidentiary hearing in which Mr. Mello and others are compelled or will be compelled to testify to explain why he shouldn't be disqualified from the case. So there's a lot going on.
It's gonna be fun to watch. Last night, KLM says you said you hadn't seen the court TV clip. Oh yeah, Mark was on with Nurse Kim last night. If you didn't watch it, go back and watch that. It was a good show. I watched it. I was there lurking around. You said you hadn't seen that court TV clip with the lawyer who hates Karen Reed, the satanic lawyer. Can you ask him if you found it and his thoughts? Thank you, KLM, for the time.
I didn't. I probably should. On the other hand, I mean, any lawyer who is ostensibly on to give sober legal analysis, who comes swinging guns ablazing out of the gate, saying how much he hates her and wants her to go down. I mean, at that point, if you have a law degree and that's how you're talking, I mean, I'd be changing the channel. So at that, I mean, I don't know what he said. It doesn't make any sense to me. It doesn't sound credible, but I probably should go watch it.
Well, you know what? I mean, since you're here, if you have a couple seconds, let me pull it up because it just blew my mind. I'm like, does this guy think that he's gonna like get any more business out of this? And what I thought was one of the most interesting things about it.
Go ahead.
Is that this guy, they call him a national criminal attorney, but he's not. He's a personal injury lawyer. So, which is, so am I. So, I'm not going to diss the guy for that, but he should know what kind of injuries are caused by a pedestrian case versus motor vehicle. And it's embarrassing. I felt so bad for Matt from Court TV. Remember, he was in the courtroom every single day at the Karen Reed trial.
So if you're miscredentialed, you should correct the record. I mean, if you're not a criminal defense attorney, and of course, this is going to make Court TV look worse than, some clown they put on in platform. I mean, they're the ones who did it.
Is it even possible to make them worse? Here we go.
Of Michael Jaffer, national criminal attorney. No surprise, Michael, that the judge made a ruling that the civil trial can't take place until after the criminal is wrapped up.
I agree with the judge's decision. Look, I hate Karen Reed. I detest this woman. I want to see her convicted in her next criminal case.
Can we hear more? Now you got.
Oh, it gets better. Okay, good.
But I want to see it done the right way, right? Had the judge not done this, obviously it would have divided the community further because she's created this whole entire conspiracy hoax. She's made the whole thing up. And so because of that, there's division in that community that she sowed herself intentionally to deflect attention from herself. With that being said, the judge could have forced her to go forward with the deposition and she would have just invoked her Fifth Amendment privileges, and that would have created a negative inference in the civil case. It could not create a negative inference in the criminal case that's going to come, but it would have created a negative inference in the civil case. But then it would have just played into her whole entire narrative of, look, the whole system is against me and I'm a heroine who's fighting to protect the system. I think the judge made the right decision. I'm proud of the decision. I think the decision was right. I don't think she should have been forced to move forward with the deposition in her civil case. It could wait. Her criminal case is right around the corner. This could wait. Civil cases last years, by the way. They're not like criminal. They last years. And so this is not. It would have been way too fast to force her to be deposed before the criminal case. And obviously the attorneys for the family wanted it done this way. They also made the right move. It was a chess move to force her to toe the line and file this motion. And so everything happened the way it should happen. The system worked for now. And I'm proud of the decision that the judge did.
Wow.
Yeah, and the threshold.
He's proud. Wait, it gets better because we're not done
A lot
yet.
of words said. There's more words salad.
Yeah, there's more. He's going to keep talking.
To remind our viewers is much less in a civil case than it is a criminal case. But again, that deposition could have been used against her in court because she would have been under oath. It's almost making her testify before the next jury gets the case. But you know what could be used in court, what wasn't used in the first trial, but is still on the table, is all of the interviews that she's been doing on national news.
Yeah. By the way, I hate this woman, and I hope she puts her foot in her mouth. I hope that she has enough, basically, metaphorical rope to basically hang herself with her interviews.
Metaphorical rope to hang herself, as if Michael Proctor did not say, I hope she just would kill herself, as if Sandra Birchmore wasn't actually metaphorically hung and it was ruled a suicide. And then it really turns out Farwell killed her. But let's just let him keep talking.
She's a narcissist. Again, these are my opinions, obviously, not that of anybody else. My opinion is she's a narcissist, and she's worried about one person and one person only, Karen Reed. I'm not saying she's that thing because of the fact that she defended herself and she pled not guilty and she vigorously defended herself. Everybody has a right to do that. That's not at all the problem. The problem is when you defend yourself, but then you lie and you blame an entire community and a police department that has been riddled with its own controversy, to do that in order to deflect attention from yourself so that you don't get pulled over that night for a drunk driving and go to jail for a felony for driving. And even if you accidentally hit John O'Keefe, but you were so drunk that it becomes a felony that has mandatory prison sentences. When you do that, when you go back to his house, when you put up a story that you are being framed and all of it has been debunked, when you do that, I believe that you're a narcissist, and that's why the interviews don't shock me. I'm sure she's going to have a book deal. She's going to have a book deal if she gets acquitted in the second case. She's going to spend the rest of her life smugly claiming that she stood up to the system and won, right? So I really hope she gets convicted in this next criminal case. I'm proud of the civil suit. I think the civil suit is going to, even if she gets acquitted in the second case, that civil case, she's going to get found responsible for his murder in the civil case. Again, a prediction by me, and she's going to spend the rest of her life paying tens of millions of dollars of getting her bank account seized or real estate seized. I think this woman's got some problems for the rest of her life that she created with her own narcissism.
All right. Well, that's your opinion and your legal analysis. But, that's why this case has divided so many, right? Because
Big Case Mike talking about a narcissist.
That's Big Case Mike. Do you think Mike's going to get any more big cases after this one? After this appearance?
I'm sure if Big Case Mike had been called by Karen Reed to represent her, he would have done so in a heartbeat because it's a big case and, Big Case Mike. Look, this is why people hate lawyers. Let's be honest. He knows nothing about the case, clearly. He has a vitriolic dislike and hatred even for somebody he doesn't know. He was introduced as an experienced criminal defense attorney, and he's openly rooting for her to be convicted, not even focused on, well, the evidence establishes it. He just wants her to go down because I think she's smug and a narcissist and has destroyed a community. This is, again, it's just why people don't like lawyers. And
yeah, Court TV.
Court TV needs better screening. And I don't know, maybe Big Case Mike is good at what he does. But that was just embarrassing. That's if I'm the editor or the producer at Court TV, I'm just saying, what are we doing? That's probably the best anchor they have or the best reporter they have at Court TV, and you humiliate him by putting on that word salad of hatred.
Yeah, he was in the courtroom every day for Karen Reed. Matt Johnson, I think his name is, and he's a nice guy, and I feel bad for him. I think he must have went home and screamed at his booker like.
Why would any lawyer go on and just, again, come out guns a-blazing saying how much he hates someone, as opposed to saying, look, the judge did the right thing. He did her a favor. Maybe, she's at risk of incriminating herself. And how did this turn into she's a narcissist? I hate her. I hope she goes down. I hope she, proverbially hangs herself, as you pointed out, which is in poor taste. and then just rants and raves about nothing. And, the sad thing is, it's not like his legal part of what he was talking about was wrong. I mean, he doesn't sound like a complete dope. He just sounds like a clown with a law degree.
But when you throw in your personal hatred for a defendant that you don't even know,
it makes no sense. I don't know if that was a shtick to try to provoke and get clicks and likes. If not, I just don't know why you would care. As a personal injury attorney in Michigan, is that where he was from?
Yeah, I think
where
so.
he is, he's again described as an experienced criminal defense attorney. He's nodding his head yes. Well, that's not true, obviously. And then just go into that diatribe. I just think that's useless television.
Unprofessional and vitriolic. Marcello, where are the witness intimidation charges on him? Right.
It's funny you say that. Come to be careful if you come to Massachusetts. Big case.
Yeah.
You might become the subject of a big case if you do that.
That's right. I don't know if they'll be calling him again because the comments on YouTube on that video are just he got ratioed. Let's put it that way. He got ratioed.
I don't get it. Like, what is that? Is that all shtick? Is that just to get attention?
He's on there a lot, apparently. He's had like a lot of appearances on there. I mean, I don't know if nobody else will go on there anymore. I mean, last time they wanted me to come on. I said, well, who's coming on with me? And they said, Wendy Murphy. And I said, oh, absolutely not.
Well, they were gonna one time, they wanted me to go on with, somebody who lives in the attic. And I said, absolutely not.
Mm-hmm.
And I said, don't ever invite me again if he's on. And they never invited me again. But they had plenty of adequate substitutes, as you've seen.
Mm-hmm.
Yes. One of their famous commentators today was on Twitter. Someone had said, had you read these letters? And this was sent to me, so I looked at it. And she said, I don't need to look at them because anyone who represents, the blogger, if you will, is unscrupulous, and I don't care what they say. And I read this, and all I could think of was, okay, whatever. Everyone's entitled to their opinion. And I'm thinking, and I don't hold this against Hank Brennan.
Mm-hmm.
I'm unscrupulous because I represent somebody who you believe is harassing people.
Mm-hmm.
Okay?
Or somebody that you just hate, basically.
Fair. Okay.
Mm-hmm.
But you're openly like rah cheerleading for a defense attorney, now turned prosecutor, who represented the most notorious mob boss in Boston for 25 years and was single-handedly responsible for probably dozens of murders, millions of other economic harm, millions of other terrible things. But because he's on the side of justice in what you perceive this case, he's scrupulous. And you just look at these people and you say, they're not serious. I mean, but that's what court TV has become. And, it wasn't always like that,
No, it was the gold standard. Come on. Back when the OJ trial was happening, like that was the go-to.
I mean, you've seen some of the other people they've put on too, some of your, and the Wendy Murphys,
mm-hmm.
Other people I shouldn't name, but you get it. And just say, wow, have they fallen a long way from, the OJ Simpson coverage days and all that.
Yeah, it's embarrassing. It's sad. And, that's why people are turning to YouTube for their news, because nobody really trusts what mainstream media has to say anymore. It's like, you don't know who to believe. Listen, I was going to go to the Daniel Penny trial today.
Huh?
And then I'm thinking, today's not really a good day to go to the city. And then I'm like, oh, I'll go tomorrow. And then like, tomorrow's definitely not a good day to go to the city. And then I'm like, well, maybe I'll go Wednesday. And then I was like, the world could be over by Wednesday. Like, I don't know what's going to happen. Like, literally the world could end.
Yeah.
Could be the end of the world as we know it by Wednesday. And
they're probably not sitting tomorrow, I would imagine, although I don't know.
Do they close for election day? You're right.
Yeah.
They used to. I mean, courts, yeah.
I would think, although the judge in that case, who I remember from using the DA's office when I was there, he's kind of a hardworking guy. He'd be the one guy I'd be like, we're going to do it.
Right.
But, obviously, if you're going down there, let me know, because that's like my home.
Free Daniel Penny. I say free Daniel Penny. So let me know next time you're going to be. I'll meet you. Let's go, because I'm all about. Did you see that they released body cam footage?
I know that case well. I've commented about it initially. He
had a pulse.
I know. No, that's really troubling. I shocked a lot of people in the early part of the case because they were asking about the charges. And, you know, my view was, as a legal justification case, legally, by the letter of the law, the charges are warranted. But I said, practically, he's not going to get acquitted. There is prosecutorial discretion given what's going on. I think it's a bad prosecution. But if you want to have like a law school evidence exam, then it's probably a good case. And several months ago or a year ago, I went on Fox and Friends, the morning to talk about it. And, you know,
wait, on Fox News or on Channel 5 like Rosanna Scotto?
Fox News with, Brian Kilmeade and, that crowd. And I think I kind of shocked them a little bit just because they were under the impression I was probably going to say that, oh, no, this is like not justifiable in the sense of prosecuting him. And I, said, no, it like the justification is legally suspect, but in the real world, I don't know why they're prosecuting him. And then when you learn today that he had a pulse,
and he was breathing. Like you like they released, I think, that footage. I don't know if it was shown in court on Friday. That's when they opened, or it just leaked on Friday. But the first responders are clearly like, you got a pulse, and they're all feeling all his pulse points. They're like, I got a pulse. He's breathing. Yeah,
that's problematic for the prosecution, especially when you wrap in nullification, juries of subway riders, and all the other stuff. I mean, no, that's one we could talk about for hours on end. That's one that I've tried a lot of self-defense cases and justification cases.
Mm-hmm.
Those are the most interesting, and certainly, a death on a subway, given what's going on here, it's a fascinating legal case. It does feel a little bit pandering to bring the prosecution, to be honest, though.
They found he had synthetic marijuana and some other psychotic drugs in his system. And the witnesses started testifying today who were on the train.
The girl,
and they were afraid. A lady with a stroller with a baby. Like, I thought he was going to kill. Like, this is, if my kids were on this subway train, I would want Daniel Penny on that train. And, a lot of them are calling him a former Marine. No, once you're a Marine, you're always a Marine. Semper Fi.
That's true. Anyone who knows the Marines knows the code. A Marine is a Marine for life. There is no such thing as a former Marine. But anyone who rides a subway has been in this situation. And of course, it's always the worst when you're in between stops and you're there. I mean, you're trapped. You're in the sardine can with nowhere to go. And it's certainly unfortunate that a guy lost his life and this and that. But if you recall, people wanted him prosecuted for murder as if it was an intentional killing, and that's absurd.
Luckily, he has some supporters, and people raised a lot of money for his defense. And
oh yeah, no, I would be pretty surprised if he gets convicted. I mean, it's just,
you never know. It's going to depend on, somebody said it's going to depend on the makeup of the jury. You're right. I mean, like I don't know what to think with juries anymore.
They're not going to get 12. There are, again, a Manhattan jury, you're going to get subway riders. You're going to get people who've seen people running around threatening. Whether he was in a mental health crisis or not, the bottom line is that he was threatening, out of control. To me, the legal issue is interesting. Did it warrant the use of what apparently was deadly force? And of course, it has to be proportional. In other words, does there come a point in time where he was immobilized, the threat was immobilized, that he should have let go? Again, those are, to me, all the legal points that are interesting. But in the real world, I don't see how a jury of 12 normal New Yorkers, I know that sounds like an oxymoron, 12 normal, impossible, but would literally find this Good Samaritan Marine guilty of literally manslaughter, as it were, in this case, where he could theoretically go to prison for doing what he did, which clearly was done out of good nature, whether you think he went a bit too far or not.
Agreed. All right, let's go. Let's cover it.
Yeah, no, that's there's we'll show you the places in Chinatown and Little Italy down there.
Yeah, good. Let's do it. All right. Final thoughts before we wrap. Thank you all for hanging out with us. 3,805 of you. Smash that like button. It's not going to hurt you, even if you hate watching. Smash the down button. I don't care.
What are
engagement?
I wouldn't read too much into the case being adjourned. It's kind of normal. I mean, trial get moved all the time.
Yeah.
They are going to get new experts. That takes time to get reports. Takes time for the defense to analyze them.
And they consented.
They consented. It takes time for them to get their own experts. So I don't think there's anything going on here tactically or strategically. And I wouldn't read too much into it. It's kind of been an interesting couple of weeks. I know there's been a lot of tension online about.
That's why I don't go there. I don't play in that playground.
No, it's just immediate. Yeah, I get it. It's just everyone should chill maybe and just, whatever.
New York doesn't have stand your ground, does it? I
No.
mean, we have self-defense, but
New York is interesting. Their self-defense in defense of your home would be shocking to most people. In New York, if you believe someone is committing a burglary in your home, you're authorized to use deadly force, no questions asked. So if somebody is crawling through your window in New York, you can put one right between the eyes, no questions asked. That's a justifiable homicide. And you'd say in New York, of all places.
right, because we're not even open carry. Like, it's hard to get a gun license.
But in New York, if you're going to use deadly force, outside the home, you have a duty to retreat unless it's not possible. So, it gets really, really complicated. So it's not a stand your ground state. It's not Florida like that. But if you're in your home, you can shoot to kill and that's it. You're justified. Even if it's an innocent person trying to play a joke by banging on your window. If you reasonably believe they're about to commit a burglary, it's crazy, but that's the way it is.
I love Little Italy better too. Let's go to Puglia for lunch.
Yeah, although Chinatown has expanded way past Canal Street into half of Little Italy. But there's obviously good stuff.
I do. And if we go down there, then I can get my knockoff Goyard tote that everyone seems to need. We need some bags. Yeah.
Of course, the sad thing is there's no more Forlinis, as you know. So
I know.
The classic,
we got Ferraras, we got, Little Vincent's, we got Puglia. Still some good places to eat.
Yeah, they're all still there. Yeah. Yeah.
All right. That's it, you guys. Thank you so much for hanging out with us. Just smash the like on your way out. Like us, comment about us in a kind way. And we'll see y'all real soon. Thanks for coming, Mark.
Thanks for having me.
Very spur of the moment. It's good to be spontaneous, isn't it?
It is. It is.
All right, you guys. Peace out. Thanks, mods.
Bye.
Bye.